As Donald Trump awaits his fingerprinting tomorrow at the Lower Manhattan courthouse, there are some really big developments in another criminal investigation into the ex-president, the federal probe into his handling of classified documents. Fox host Bret Baier reports, quote, multiple Secret Service agents connected to Trump have been subpoenaed and are expected to testify before a Washington, D.C. grand jury, likely on Friday. We can't independently confirm that. Now, that grand jury is part of the investigation run by special counsel Jack Smith. And now the Washington Post reports that, quote, federal investigators have gathered new and significant evidence that after the documents subpoena was delivered, Trump looked through the contents of some of the boxes, apparently out of a desire to keep certain things in his possession, people familiar with the investigation said. A Trump spokesman claimed the reporting is part of, quote, prosecutorial misconduct by illegally leaking information. But here's the thing. Trump basically admitted to looking through the documents last week.
I've known you for decades. I can't imagine you ever saying, bring me some of the boxes that we brought back from the White House. I'd like to look at them. Did you ever do that?
I would have the right to do that. There's nothing wrong with it.
But I know you. I don't think you would do it.
Well, I don't have a lot of time, but I would have the right to do that. Right. I would do that. There'd be
All right, let me move on.
Remember this. Yeah. This is the Presidential Records Act. I have the right to take stuff. Do you know that they ended up paying Richard Nixon, I think, $18 million for what he had? They did the Presidential Records Act. I have the right to take stuff. I have the right to look at stuff.
Mary McCord served as the acting assistant attorney general for national security as part of her nearly 20 years as an assistant U.S. attorney in Washington, D.C. She's also the co-host of the new podcast from MSNBC titled Prosecuting Donald Trump, and she joins me now. Let's start on that not quite admission, because he's talking hypothetically. Hannity says, well, you wouldn't have them bring you the box and go through it. He says, of course I would do that. Of course, it's mine. I have a right to that stuff. This does seem to be the nub of the issue, right? Did the ex-president personally inspect and then choose to retain information that was later found in the search?
Yeah, I mean, we used to call that kind of a question when I was a prosecutor a softball, meaning there's a really easy answer here, but Trump declined to give that really easy answer. You're right, though. What it looks like Jack Smith is focusing on is this key time period between the service of the subpoena on May 11th and then June 3rd, the date that the Department of Justice officials and the FBI visited Mar-a-Lago. They were provided with a package of 38 classified documents, including 17 with top secret markings. And they were provided with a letter signed by, we know now, by Christina Bobb, one of the president's attorneys at the time, the former president's attorneys, certifying to having conducted a diligent search and there being no additional classified records at Mar-a-Lago. So that time period now, this breaking news we've seen with the Washington Post and other reporting is, I think, focused on, did the president between that subpoena and June 3rd, and perhaps even after that, but particularly in that time frame, did he look through those documents himself and maybe make some decisions about what he did not want to turn over? Because a key crime here that's being investigated is obstruction of an official proceeding. That includes not only concealing and failing to provide documents to the FBI during an official proceeding, but also falsifying any record. So that letter, if he was involved in that letter, could also be key evidence of obstruction.
Yeah, I mean, so the facts as publicly reported and established are bad enough, right? That you've got a subpoena, you've got him turning over documents with a certification lawyer saying there's nothing left, then a search which finds that document was false, right? So that's established beyond a reasonable doubt, right? Like, we know that there were classified documents. So then the question becomes, was it sloppy oversight, or was there intent here? And this evidence, I mean, just to read you a few more parts, because I want to get your feedback on the legal significance of this. So they report in October that Trump's valet, Walt Nauta, has told investigators that he moved boxes at Mar-a-Lago at the former president's instruction after the subpoena was issued. Smith's team has video surveillance footage corroborating the account. They have also amassed evidence indicating Trump told others to mislead government officials in early 2022, before the subpoena, when the National Archives and Records Administration was working with the Justice Department to try to recover a wide range of papers, many of them not classified, from Trump's time as president. There seems to be a lot of evidence here of motive and knowledge and intent.
That's right. And that is key, because a mistake, can't be obstruction of justice. The concealing, the false documents has to be done with intent to obstruct or influence an official proceeding. And an FBI investigation is by law an official proceeding. And I will tell you another thing about intent. All of that information that we're seeing and evidence that we're hearing about being accumulated, some of it goes, directly potentially to his intent during that time period, post-subpoena, pre-June 4th. But some goes even before that, including even some evidence I'm seeing in the reporting, some information that he intended to sort of, obstruct the archives, even getting things that weren't classified, because he feels that he should be entitled to that. He's just wrong about that. That intent, that kind of evidence can come in a trial, not to prove action in conformity with a previous intent, but to actually prove intent. It's called other bad acts evidence. And even though that's normally excluded because a jury needs to find, in any case that the intent was there for that case, you can put in other bad acts as evidence to prove intent.
What you just referenced, which we just saw in that clip, is that he clearly has a theory of the law here, which is that it's all his. I mean, and he's not been shy about that. He says it to Hannity. Of course I would do it. It's all mine. This is essentially all made up. He and others have said I can declassify things with the power of my mind. I can telepathically turn them over. There's evidence here also amassed by the reporting of the Washington Post that he sought advice from other lawyers and advisors on how he could keep documents after being told by someone in his team he could not. People familiar with the investigation said. They have collected evidence that multiple advisors warned Trump trying to keep the documents could be legally perilous. Does it help him if he has a completely erroneous, sincerely held theory of the law that everything is his?
So, again, if we didn't have all this kind of information we're getting about legal advisors telling him, what the law is, and that presidential records are not yours, they are public, they are not private records. That's what the Presidential Records Act was all about after Nixon himself tried to destroy presidential tapes, right? And so this, what he's trying to do now is, I think, trying to create this facade that he actually innocently did this. But we know, or we expect that the evidence that will be presented, if there ever is an indictment and trial, will show that he was advised time and time and time again that these were not his records.
I got to say, the reporting suggests to me an indictment is more likely than I thought it was a week ago. Mary McCord, thank you very much. Appreciate it.